Welcome to Talk Testimonies. You're with us for a shortcut to understanding a crucial Supreme Court decision.
Glad to be here.
Today, we're really diving deep into United States Patent and Trademark Office, et al. Booking.com BV. And at the heart of this case, there's this really interesting question, isn't there, about branding in, well, the digital age.
Absolutely. It boils down to this. Can you take a word that's pretty generic, like booking, slap a .com on the end, and suddenly have a trademarkable brand?
Exactly. That was the core question for the Supreme Court. Could Booking.com actually get registered federally as a trademark?
Yeah, sounds simple on the surface, but the implications are pretty significant for online businesses.
Okay, so let's jump right in. What was the final verdict? The quick summary.
Well, the court ultimately sided with Booking.com. They ruled that, yes, Booking.com can be trademarked.
Okay, big win for Booking.com then. So let's unpack how we got there. What was the argument from the other side? The USPTO, the Patent and Trademark Office, they were the ones saying no, right?
That's right. They were the petitioners. Their main argument was, well, basically that Booking.com is just generic, full stop.
Generic like how?
Like saying Booking Incorporated or the booking company. They argued it simply describes what the company does, offers booking services, and the .com just tells you it's online.
Okay, so just descriptive.
Exactly. And their big concern was about competition. They worried that giving Booking.com a trademark would essentially block competitors from using similar descriptive domain names.
Which is a huge deal online.
It really is. Because, unlike just using a generic word in your company name, only one entity can own a specific domain name like Booking.com. So trademarking it adds another layer of exclusivity.
That makes sense. You don't want someone to effectively own the dictionary term for an online service.
Precisely. The USPTO relied heavily on something called the primary significance test. It's part of the Lanham Act, which is the main federal trademark law.
And what does that test look at?
It asks, what does the term primarily mean to the relevant public? Does it mean a general class of services, or does it point to a specific source for those services?
Oh, okay.
And the USPTO argued that for the public, Booking.com primarily signifies the generic service online booking, not the specific company, Booking.com BV.
Did they have any legal precedents they were leaning on?
They did. They pointed to the Goodyear case, an older case aiming to prevent companies from monopolizing really generic terms. Think like trying to trademark rubber company if you just sold rubber.
Right, or wine company if you just sold wine.
Exactly the examples they use. They saw Booking.com as the modern digital equivalent of that. The .com is just like adding company or Inc. It just indicates the type of entity, in this case, an online one.
So their fear was this would set a bad precedent.
A huge one. They were worried about opening the floodgates. Imagine everyone with a generic term .com applying for a trademark. Travel.com, hotels.com.
Which, actually, some of those are registered, aren't they? We'll get to that.
We will. But the USPTO's fear was the trademark system would basically morph into a secondary domain name registry, creating a massive backlog and confusion.
Makes sense from a practical standpoint, too.
Definitely. And they also argued, look, Booking.com already has a massive advantage just by owning that domain name. It's prime digital real estate, giving them trademark protection on top of that. The USPTO felt that would just unfairly amplify their power in the market.
What about consumer evidence? Did Booking.com try to show people recognize their brand?
They did. They had survey evidence, but the USPTO was pretty skeptical.
Why skeptical?
They suggested, well, maybe consumers only associate Booking.com with one company because structurally that's how the internet works. You type in that one specific address to get there.
So it's about the address, not necessarily the brand recognition in the traditional sense.
That was the USPTO's counter-argument. They felt it wasn't necessarily proof of source identification, just recognition of a unique web address. And they generally pushed back against relying too heavily on survey evidence alone to decide genericness, citing concerns about, potential bias or subjectivity in how surveys are done.
Okay, so a pretty comprehensive case from the USPTO. It's generic, it harms competition, the domain itself is advantage enough, and the survey evidence might be misleading.
That sums it up well.
All right, let's flip the coin. What was Booking.com's argument? How did they convince the court they deserve this trademark?
Booking.com also focused on the primary significance test, but obviously came to the opposite conclusion.
Naturally.
They argued that you have to look at Booking.com as a whole. And when consumers do that, they argued it does function as a source identifier. It points to their specific platform.
And they had proof.
Yeah.
That survey data.
Exactly. They presented their surveys, which they argued showed that a significant majority of consumers actually identified Booking.com with one specific company, not just any old online booking service.
So they claimed it wasn't generic in the minds of consumers.
Precisely. They argued that the combination of Booking and .com, through their extensive use, advertising, and, well, building a reputation, had acquired what's legally termed secondary meaning.
Secondary meaning, meaning it started generic but became a brand identifier.
That's the concept. The primary meaning might be generic, but a secondary meaning has developed where consumers link that specific term to a single source.
And what about that point the USPTO raised about opening the floodgates? Did Booking.com address the other .com trademarks?
Oh, absolutely. That was a key part of their argument. They pointed out, look, the PTO itself has already registered numerous marks like rent.com, tickets.com, travel.com, marks that combine a somewhat generic term with .com. And they argued the sky hasn't fallen. There hasn't been widespread anti-competitive chaos or mass consumer confusion because of those registrations.
So they were essentially saying, you've done this before, USPTO. Why is our case different?
Pretty much. They framed it as an issue of consistency. They also stressed that trademark protection was crucial for them.
Crucial how?
To protect the brand value and goodwill they'd built up over years. And also, practically speaking, to fight things like cyber squatting, people registering similar domain names in bad faith and online scams trying to impersonate them.
That makes sense. Branding is also about trust and preventing fraud.
Definitely. And regarding competition, they argued that even though their name is Booking.com, other similar domains exist, like ebooking.com or hotelbooking.com.
So it's not like they own the entire concept of booking online.
Right. They argued their specific name, Booking.com, had become distinctive as their brand, even with other booking sites out there. It's like, you mentioned coffee shops earlier.
Yeah, like Starbucks versus other coffee places.
Exactly. Having competitors doesn't mean a strong brand isn't distinctive. They also brought up the fair use doctrine.
How does that fit in?
Fair use in trademark law allows others to use a descriptive term, even one that's part of a trademark in its descriptive sense, as long as it's not misleading. So competitors could still use the word booking to describe their services.
So they could say, we offer hotel booking.
Yeah.
Just not pretend to be booking.com.
Precisely. It limits the scope of the trademark owner's monopoly. And finally, Booking.com just reiterated that the PTO had been successfully applying the primary significance test to .com marks for decades without the catastrophic results the USPTO is now predicting.
Okay, so compelling arguments on both sides. It really highlights the tension between established trademark law and the unique realities of the internet. What were the justices focused on during the actual arguments? What questions were they asking?
Oh, they dug in deep. You could tell they were grappling with the practical consequences. They asked a lot of questions about competition. How would ruling one way or the other actually impact the online marketplace?
So the real-world impact was key.
Absolutely. And consumer understanding, too. How do average people perceive these generic .com names? Is it really different from a traditional brand name? They spent a lot of time probing the distinction between a domain name simply being an address versus it functioning as a brand identifier.
That seems like the absolute crux of it.
It really was. And related to that, they questioned the reliability and interpretation of the survey evidence from both sides. How much weight should those surveys carry when, again, only one company can own that specific domain?
Right. Does owning the address skew the survey results?
That was a definite concern they explored. They also pushed both sides on whether a clear categorical rule was needed, like, should no generic term plus .com ever be trademarkable? Or is the existing, more flexible primary significance test adequate, even if it's harder to apply online?
So wrestling with finding the right legal standard for this digital context.
Exactly. They also touched on things like trademark registrations in other countries, but the core was really about competition, consumer perception, and how to apply existing law to domain names.
Fascinating. Okay, let's put on our hypothetical robes and step into the 10th chair. If we were looking at all this, trying to decide, what's our take?
Well, acknowledging that the internet does complicate things, the court's ultimate decision to stick with the established primary significance test feels pragmatic?
Pragmatic how? Not creating a whole new rule just for the internet?
Sort of. It avoids creating a potentially messy, perhaps arbitrary categorical ban. And the evidence Booking.com brought forward, while you can debate the influence of domain ownership, it did seem to suggest, a non-trivial level of consumer recognition beyond just a place to book things.
So maybe not purely generic in the eyes of enough consumers to matter.
That seems to be what the majority felt. And this is the crucial part going forward, the responsibility now really falls heavily on the USPTO. They have to apply that primary significance test rigorously.
Meaning they can't just rubber stamp every .com application.
Absolutely not. Just adding .com to a generic word shouldn't be an automatic pass. The burden is squarely on the applicant, the company, to prove that their term has genuinely acquired that secondary meaning, that it functions as a real brand identifier in the marketplace.
So the test remains, but the application needs to be strict, especially online.
Exactly. It needs a careful, nuanced application. This case really underscores how branding itself is evolving, doesn't it? In the digital age, your web address isn't just an address anymore. It can become intrinsically linked to your brand identity.
Yeah, it's a powerful reminder that even these seemingly simple digital identifiers can gain real trademark significance through use and consumer perception.
It's a balance, always, between protecting those brands that companies build and keeping language free for fair competition. This case just shifted the line slightly in the context of .com domains.
A really important clarification for the digital economy. Well, that wraps up our deep dive into USPTO v. Booking.com. Hopefully, that breakdown gave everyone a clear picture of the arguments and the final outcome.
It was a complex one, for sure. What do you think, listening out there? Did the court get it right? Does this strike the right balance for the internet age?
Definitely food for thought. We encourage you to keep exploring the implications. Thanks for joining us on Talk Testimonies.
We'll catch you next time.
Tune in then as we unpack another significant Supreme Court case.